I would like to, excuse me, ask all of us to please turn our cell phones to silent and to make sure they're off the table so we can avoid feedback noise. You may notice board members accessing their laptops during the meeting. They are using the laptops solely to access board meeting materials that are in electronic format. This is an official meeting of the Medical Board of California, and as such, disruptions of the board's business will not be tolerated. We have designated time on the agenda for public comment and ask for public comment on each agenda item. I ask that you be respectful of the need to conduct the board's business. Should anyone disrupt the meeting, I will ask the person to conduct himself or herself in such a manner that permits the board to transact its business. This meeting is available via teleconference. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comments. To request to make a comment during the public comment period, press *1. You will hear a tone indicating you are in the queue for comment. If you change your mind and do not want to make a comment, press the # sign. Assistance is available throughout the teleconferencing meeting. To request a specialist, press *0. Each person will be limited to 3 minutes per agenda item. However, during agenda item 20? Yeah, thank you. Public comments not on the agenda. The board has limited public comment for individuals on the teleconference for 20 minutes. In addition, public comment from individuals here at the meeting will also be limited to 20 minutes. Therefore, after 20 minutes, no further comments will be accepted. During public comment on any other agenda item, 10 minutes will be allowed for comments from individuals on the teleconference line and from those in the audience. After 10 minutes, no further comments will be accepted. Mr. Melendez will be assisting me with receiving the public comments via teleconference during the meeting. Thank you, Mr. Melendez. The board welcomes public comment on any item on the agenda, and it is the board's intent to ask for public comment prior to taking action on any agenda item. If for some reason I forget to ask for public comment on an agenda item and you wish to speak, please raise your hand and you will be recognized. I would like to remind all the speakers to complete a presenter's slip so I can call you by name at the appropriate time and that the record of the meeting is full and complete. Please give the speaker slips to staff. Can staff identify themselves that will be handing out the speaker slip? Oh, thank you. Good morning. I will do my best to call upon everyone who has supplied a slip for the agenda item and recognize those who wish to make a last-minute comment. But we ask that you fill out a speaker slip after your comments so we can have it for the record. I want to remind all speakers to please stay on topic and keep your comments to 3 minutes or less. We may take some items out of the order of the agenda to accommodate today's schedule. We will get to everything. I would like to call this meeting to order. Ms. Toof, can you please call the roll?
Absolutely. Dr. Bolat?
Present.
Dr. Bishop? Here. Dr. Gonadev?
Here.
Dr. Hawkins? Dr. Kraus?
Present.
Dr. Levine?
Here.
Dr. Lewis? Dr. Yip?
Present.
Ms. Pines?
Here.
Ms. Shipsky?
Here.
Ms. Wright?
Here.
Ms. Yaroslavsky?
Present.
And Mr. Serrano-Sewell? Present. Thank you.
We have a quorum. The board is now going to go into closed session, agenda item 19. Pursuant to section 11126, subsection A1 of the Government Code, the closed session is being held to confirm the evaluation of the executive director. I would ask everyone to please exit the room. This closed session will not take long. It won't be more than 5 minutes. think this is working. Oh, hello. Hi. I appreciate everybody accommodating the board in our closed session. We are done with closed session in which the board reaffirmed its salary decision of the executive director, for the executive director. Moving to agenda item 20, public comments on items not on the remaining agenda. I have no speaker slips. Are there any comments on the phone on agenda item 20?
Any comments on the line, Michael?
Yes, we have Genevieve Cabriel.
Thank you.
Department's investigation finds there was a probable cause to arrest Gray because they sensed it didn't anything.
Public comment.
Every meeting. Uh-oh.
Genevieve,
Yes,
go ahead.
yes, good morning, Genevieve Clabrol. I just wonder what's the responsibility of a physician when they are delaying surgery. Like an example for hernia repair, many patients in LA County, their surgery is postponed for 3 years. What kind of capability physicians are responsible for in that delaying of such surgery? And what can be done about it?
If you have a specific issue or complaint, you'll have to file it with the department. With regards to your question, I'll ask staff to get back to you after this meeting. But thank you for your
Yes,
comments.
I will appreciate because this
Thank you. Thank you.
include many individuals, not just one patient, many.
Okay. Are there additional comments from the phone?
We have no further comments from the phone.
Thank you. I'm now going to take up some agenda items we didn't get to yesterday, and I'll start with agenda item 13. Thank you. And that is discussion and possible action on proposed regulations updating disclaimers and explanatory information applicable to internet postings. Ms. Romero, good morning.
I'd like to draw your attention to BRD 13, pages 1 through 6 in your board packets. This item pertains to proposed amendments to the regulatory language in California Code of Regulations, Section 1355.35, regarding disclaimers and explanatory information applicable to internet postings. Section 1355.35A lists disclaimers and explanatory information the board may provide with public disclosure information released on the internet. Amendments to this section are needed to add disclaimers and explanatory information regarding court orders, misdemeanor convictions, licenses issued with the public letter of reprimand, and probationary licenses. Section 1355.35A2 only requires cleanup as it directs the public to contact the board's central file room at its previous address on Howe Avenue in Sacramento if they wish to obtain a copy of public documents. An amendment is needed to include the current address of the central file room. Additionally, the board has received communications from physician attorneys regarding information found on our website related to administrative disciplinary actions. As such, it was determined court-ordered public disclosure screen types were needed to accurately reflect practice restrictions by the courts. Therefore, amendments to the chart found in Section 1355.35C are necessary. This chart, beginning on page BRD 3-4 in your packets, includes descriptions of the license status, which is displayed on our website, and the public definition of the status code. The amendments would add the status code description and definition for a 150-day temporary license for a family support issue and the status code description and definition for a family support suspension. Statuses must be in regulations, but these weren't. The suggested amendments are identified in your packets with underlined text for new language and strike-through text for deleted language. If the board agrees with the proposed amended text, I'd like a motion for the board to authorize staff to proceed with preparing the necessary regulatory documents for amending California Code of Regulations Sections 1355.35A, 1355.35A2, and 1355.35C, and hold a regulatory hearing.
Dr. Lewis?
I make a motion to direct staff to notice the proposed regulatory language and to hold a hearing to amend those sections.
Second, Ms. Yaroslavsky. Members, any discussion or questions? Seeing none, I have one speaker card. Yvonne Chung.
Good Good morning, Yvonne Chung with the California Medical Association. We just wanted to point out one potential omission that you may want to look at as you prepare the language. The proposed language here does not address physicians who have failed to pay their income tax and suspensions related to that. I'm not sure if it's addressed in another part of the regs, but when you do, for example, we went online and looked up a physician who had their license suspended, and it was actually quite confusing because it said his license was renewed and current, and it said that his license was suspended. So that may be an area that staff may wish to look into and provide additional clarification. I know it only affects a handful of physicians, but we do occasionally get calls about that. Thank you.
Thank you. Ms. Kirkmeyer?
Yeah, actually, that is a secondary status. The regulations are set for primary status, but the issue of how it's posted on the Breeze system, we're going to be working on that. So it doesn't have to be in the regulation because it's a secondary status, but we do have to look at how it is being posted on there.
All right, thank you. Thank you for that report. Are there any additional public comments? Seeing none, are there comments from the telephone?
We have no comments from the phone at this time.
All right, thank you. Ms. Toof, please call the roll.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Mr. Serrano Sewell?
Motion carries. Thank you. Now moving on to agenda item 15, update on the Health Professions Education Foundation. Ms. Yaroslavsky and Dr. Yip.
Thank you. The Health Professions Educational Foundation met in February and is moving forward to expand the ability of the foundation to give more loan repayment and scholarship dollars to those going into the health professions. The Stephen Thompson Loan Repayment Program since 2003 has endowed $36.6 million, which is a lot of money and a lot of people. This cycle, we were able to fund 61 of the 108 applicants, and there will be a secondary new cycle given the California Endowment is going to fund another $3.5 million, which is going to affect another 30 doctors. So we're looking forward to that application process going forward. It's going to start May 18th, and we will finish the scoring in the summer. So January 4th, we've also moved the cycle for the awards for the Stephen Thompson loan repayment to January 4th with the help of staff, and thank the medical board staff for making that switch and helping us to be more effective in the ability to do this program. So that's my report.
Thank you, Ms. Yaroslavsky. Dr. Yip, anything to add? No? Thank you. Are there any questions or comments from members? Sorry, Dr. Levine?
Yeah, just congratulations to you and Dr. Yip and the group. This started out as a gleam in someone's eye, and it's really had a tremendous impact on a lot of young people. And it's just great work. It feels very rewarding to actually be associated with the work that's going on.
Yeah, the board thanks you for your service, continued service. Are there, I don't have any public speaker slips on this item. Are there any comments from the phone on the report?
We do have a question from Khadija Lang.
Go ahead.
Good morning. I'm Dr. Khadija Lang, and on behalf of the presidents and physician members of Charles R. Drew Medical Society and Golden State Medical Association, both of which are respectively the local and state affiliates of the National Medical Association, I bring greetings to Ms. Kirschmeyer, to the administrative and other executive staff members, and the members of the Medical Board of California. I first spoke before this board in 2013 while president of the Charles R. Drew Medical Society, and in an effort to make this assembly aware of some of the concerns of California's African-American physicians, I have continued calling in, along with other colleagues of mine from throughout the state, joining in the calls in an attempt to keep these often life-threatening issues visible so as to affect some positive changes. I'm sorry?
Please continue.
Can I continue?
Yes, please continue.
Okay. we're doing this in an attempt to effect some positive changes that will benefit the physicians we represent and the patients and communities we serve. And so after 2 years, it is my pleasure to congratulate your newest physician appointees to the board, Drs. Randy W. Hawkins and Michelle Bolat, both of which are primary care physicians, Dr. Hawkins being internal medicine and Michelle Bolat being family medicine. As well as I applaud this board for giving yet another indication that you're listening to the concerns of California's physicians when we bring them before you, and moving this board in the direction of a different goalpost. This, we believe, is the first time in recent history, if not the total history of the board, that we've had primary care physicians serving, and we believe this move will give physicians in practice that are brought before you a better chance of having their situations in practice on the ground actually understood in the cases brought forth. Additionally, the forming of a committee to address the concerns voiced regarding demographics of disciplined physicians by actually studying the data and numbers to determine if, in fact, there's a documentable disparate treatment of physicians of color by this board, as we have repeatedly postulated, we being the Drew and the Golden State, and as the preliminary numbers presented by Ms. Kirschmeyer at this, I believe it was the summer 2014 quarterly board meeting, clearly support, is a welcome act. So we encourage you to continue moving forward. We hope that this ad hoc committee will be able to get things organized quickly. We support the efforts that and the support we've received from the NAACP and from BAPAC. And we hope that the board will listen to the concerns and recommendations that have been made for additional members to that committee to review the actual diversity in numbers of physicians being disciplined. So I thank you very much for your time, and I encourage you to please continue moving forward on these very important issues that affect the quality of health care that's given by physicians in this state to your constituents, our patients.
Thank you, Dr.
Very
Lang.
much.
Thank you for your comments. Are there additional comments from the phone?
We have no further comment at this time.
All right. We'll now move to agenda item 16, update on the prescribing task force. Dr. Bishop and Ms. Yaroslawski.
Thank you, Mr. Serrano-Sewell. On April 13th, 2015, the prescribing task force held another meeting. The purpose of this meeting was to discuss best practices and look for additional ideas to reduce opioid misuse and abuse. The task force has scheduled presentation from individuals who could talk about methods to assist in the elimination of opioid misuse and abuse. In addition, there was an open session where the task force heard from those in attendance regarding specific best practices in different settings. The meeting started with a presentation by an individual who had become addicted to narcotics after an injury at the age of 17. It really provided a perspective on the issue that we have been battling and how easy it was for him to continue to be prescribed medications. He talked about the need for not only appropriate prescribing and education of physicians and patients, but also the need for treatment programs to treat the thousands of individuals who are now addicted to prescription drugs. His story was compelling and really helped us understand why it is so important to do all we can to eliminate the inappropriate prescribing of opioids. I want to just take a minute of personal privilege to compliment the staff, specifically Ms. Kirchmeyer and those that had to do with this presentation. Quite often when we are not aware of what's going on, we assume maybe nothing is going on. But the work that's going on around the state with the task force and with the bringing together those parties that are really at the forefront of what's going on really showed up in this meeting. I can't tell you how impressed I was, not only with the stories of the people we heard from, but the level and the caliber of those that were present, including the Insurance Commissioner's Office. So I want to thank you, and I apologize, Dr. Bishop.
Thank you. The task force also heard from Julie Nagasako from the California Department of Public Health on the work being done by its prescription opioid misuse and overdose prevention work group. There are several entities involved in the work group, including the Department of Public Health, the Department of Health Care Services, the Department of Justice Cures program staff, the Department of Education, the Emergency Medical Services Authority, and multiple boards within the Department of Consumer Affairs. Additional participants that are being invited include the Division of Workers' Compensation, the Department of Corrections, Department of Managed Healthcare, and the Department of Insurance.
The task force also heard from Dr. Das, the Executive Medical Director of the Division of Workers' Compensation. Dr. Das spoke about the division's new guidelines that are going through the process of review and completion. We discussed how it was important for the division's guidelines to not conflict with the board's new guidelines and that we all need to work together. After all of these updates, the task force opened it up to hear on best practices to battle this epidemic. Numerous speakers spoke about systems that are already in place to provide opioid management and improvement. One system provides an analytic tool that translates best practices into an algorithm to quickly identify outliers. Educational feedback is then provided to the prescribers in order for them to change their practices. Several entities perform these types of service. The issue is that the people that are receiving the information don't always open the envelopes to hear the information, so they're going to have to work on that.
The task force received a number of good ideas and also discovered much work by multiple parties is already being done with respect to this issue. We will continue to put together best practices that can then be placed into the MBC newsletter and on its website. We also consider inviting some of these individuals to speak at future meetings of the board. Are there any questions?
Dr. Hawkins?
Where could interested parties get printed information about the work that's been done thus far? Is that available?
We have the webcasts of the meeting. That's really where they can get it, and then we can go back and get you minutes, basically, from the updates that we've provided on that task force.
Thank you, Ms. Kirchmeier.
Are there Dr. Levine?
Just a question. Is there a schedule for future meetings or potential agendas for future meetings?
At this point, we haven't set a schedule for future meetings. We're kind of struggling at this point where to go from here, because now we've gathered a lot of information. I think what we really need to do is put it now into something that we can look at some best practices that we could put maybe into, we were talking about like a pamphlet or a flyer that we can put, or put it into our newsletter, just getting some information about what's available. But at this point, future, I'll have to meet with the two task force members and see where we want to go from here.
One possibility would be to reconvene another summit if there was interest in somebody in funding it, like the DEA, to report on progress since we began this work, and to actually try and get some data to look at what has happened in terms of opioid prescribing since the first conversations about this a couple years ago. And ask representative groups to showcase what they've done and what the results were, not just the processes, but the outcomes.
Right. Yeah, we actually, Ms. Harold and I have been talking about this over the last couple weeks about how we need to get another forum. We did the one in the Bay Area. We need to do one in Southern California and bring a lot of what we've gathered in our task force together. And then I know in our California Department of Public Health work group, they're working on statistics right now. So it might be prime time once they get to the point where they get the data in, we can roll it all out at the same time. We were thinking about maybe fall of this year for another forum down in the Southern California area.
It's a great suggestion. Yes.
Actually, we do truly appreciate Dr. Bishop and Ms. Jaroslawski for all this hard work. I agree with Dr. Levine. I think we need to, there are ways we can apply for a grant, both between pharmacy and pharmacy board and medical board. And in the end, we want to make a difference and show the difference. That is, look at the numbers before, look what we're doing, and then what are the numbers afterwards. And that's the only way you can prove it that we made the difference. I think it's a great idea.
Dr. Lewis.
And just remember, excuse me, just remember that the cures requirement is going to have a big impact on prescribing. So not only from the work of the task force, but you're going to see huge numbers and changes in the amount of opiates prescribed just because cures being a requirement. So,
are there additional comments from the board?
I tried to be quiet.
Oh, please. I guess we're taking comments from the public. Hello.
I'll go back. I just have a fact, actually, in light of your comment.
We pulled Cures reports.
Can you state your name for the record,
I'm
please?
sorry. I'm Virginia Harold. I'm the Executive Officer of the Board of Pharmacy. We pulled Cures reports to see what the reclassification of hydrocodone meant in terms of the number of prescribers or prescriptions written. So during the same period, we compared October through March of 2013 and 14 to October 14 and 15 for the same period. Hydrocodone prescriptions dropped 20%, and that was still in the period during which the DEA was allowing refills. So there has been an impact just out of the reclassification. During the same time, OxyContin prescriptions increased 2%. So kind of just a net, and that could have just been a variation. But we did see a marked increase or decrease in the prescribing of hydrocodone.
As you go forward with those, that information data collection, you might want to take a look at what is the increase in heroin use.
Okay.
Yeah, that doesn't get reported into Cures, though.
All right, yeah.
I'm just suggesting.
We need to proceed. Yes, Doctor.
That's a DOJ.
I'm sorry to kind of jump you this way, but after the presentation on the Cures bill yesterday, I myself, and I know many other board members, were quite disappointed that the pharmacists were left out of this. And I was just wondering if you had any comment on that.
That was done by the associations. We think that everyone should be researching Cures on a regular basis as a routine way of practice.
Thank you.
Thank you for your comments. Are there any additional public comment from those in the audience? Thank you. Any comments on the phone on this report, the prescribing task force?
And we do have comment from Genevieve Clebriol.
All right. Genevieve, would you make your comments?
Additional public comment from those audience? Any comments on this report, the prescribing task force?
Yes, good morning, Genevieve Clabrol. I am very concerned because only about 1/3 of the pharmacists are even signed up to utilize Cures. And this program is still highly not efficient. And the big concern I have is that on workman's comp, so many of the physicians are concerned about drug addiction and so on, that they don't prescribe pain medication to people who are under workman's comp. And they don't treat. If they treat the injury, people will not need drug to control the pain. So I think something needs to be really looked at in that section. And you have a lot of physicians now who are not very sophisticated when it comes to pain management. And workman's comp, lately in particular, denied 5 out of 6 recommendations from physicians for medication. So I think we need to really look at that. Thank you.
Thank you for those comments. Are there additional comments from the phone?
And we have another comment from Khadija Lang.
Dr. Lang? This is a report on the prescribing task force.
Thank you. I just wanted to make a comment that I am concerned that what I am observing in the inner cities of Los Angeles, I can only speak for that area, but I am finding that patients are having great difficulty, patients that are genuinely in pain, patients with cancer, patients with bone fractures, and you give them the prescription, we go through the process, but the pharmacies in these neighborhoods are basically refusing to carry it or refusing to honor the prescriptions. I've had patients come back to me and tell me the pharmacy told them, ask your doctor to give you some Motrin or ask your doctor to give you some other medication. So the pharmacists in some cases are so afraid to dispense this medication. And on the other hand, I've called in prescriptions for patients of mine that are in the valley, and I make a simple phone call to the pharmacy, and they just take it right through, and the patient gets that controlled substance. So I think that something needs to be done to make pharmacies and physicians that are in areas that are more heavily watched feel comfortable and able to get medication for patients that are genuinely in need of controlled substances. I have a colleague that's 81 years old, still practicing medicine, had a tooth pulled recently, and his dentist, the oral surgeon, gave him a prescription for Norco. He said he went to 3 pharmacies in the neighborhood and could not get it filled. I have a patient that had a fentanyl patch for pain, written by a pain specialist. But because she didn't get it filled while she was in a different neighborhood where the pain specialist was, she brought it to her home pharmacy, which is in South Los Angeles. She could not get the prescription filled for 5 days. And these are people that are not, these are patients that have a history of purchasing their drugs at a specific pharmacy, so the pharmacist can see their records. They can see they don't have a history of substance abuse prescriptions coming through, that they've got all of the routine blood pressure, diabetes, and arthritis and cholesterol medications. But in certain areas, it has really become a major challenge for patients to get the medications they need for appropriate pain control. And then on the other hand, we as physicians can be cited if we do not provide appropriate pain control for our patients. So I think it's extremely important that we get a handle on the substance abuse problem, especially those patients and physicians, bad apples, that are misprescribing and abusing the medications. But I think for those patients that are genuinely suffering pain, it's important that we find a method that will allow them to be able to get adequate pain medication.
Dr. Lang, it's David. If you could just 15 more seconds.
No, that's my only concern, is I want us to be aware of how this is impacting certain patients in certain areas.
Thank you for your comments, Doctor. Seeing no further comments, we'll now move to item 21. This is a regulations public hearing on continuing medical education. This is item 21 on the agenda. Amendments to sections 1337 and 1338 of Title 16 California Code of Regulations. This proposal would allow approved specialty board CME used for maintenance of certification to meet the CME requirements for renewal of a physician's and surgeon's certificate. I am David Serrano-Sewell, and president of the board, and will be presiding over this hearing. This is the time and place set by the medical board to conduct a public hearing on the proposed regulations to amend sections 1337 and 1338. As noted, the board is considering to amend these regulations relating to CME. The proposed amendments will authorize the board to accept maintenance of certification, CME, as meeting the board's CME requirements for renewal of a physician's licenses. Further, the proposed amendments will allow the board to accept MOC CME proof directly from approved specialty boards, thereby streamlining the process for physicians and complying with audit inquiry. For the record, today's date is May 8th, 2015, Friday, and this hearing is beginning at approximately 9:43 a.m. We ask that persons in attendance print their name on the roster at the room's entrance. If you wish to testify, please indicate that on the roster sheet. The purpose of this hearing is to receive oral testimony concerning the regulatory proposals described in the notice. Regulations must comply with 6 legal review standards, which are: 1, necessity. Is there demonstrated evidence that there is a need for the regulation? 2, authority. Does the board have legislated authority to adopt the regulation? 3, consistency. Does the regulation conflict with other regulations or statutes? 4, clarity. Can the regulation be easily understood by those affected? 5, non-duplication. Does the regulation duplicate other regulations or statutes. 6, reference. Which statute does the regulation implement, interpret, or make specific? Testimony should seek to address these 6 standards. Before we begin, I would like to briefly describe the procedures that will be followed. The entire hearing will be tape recorded. Those persons testifying will not be sworn in or cross-examined. All recommendations and objections will be considered by the board members. Responses to all objections or recommendations will be included in the final statement of reasons. The board will maintain a rulemaking file of this proposed regulatory action. Written comments for the regulation being heard today must have been received by 5 p.m. on April 20th, 2015. The recording of this hearing, written testimony, and all written comments received by the deadlines as noticed will become part of the official rulemaking file. A completed copy of the rulemaking file will be available for review at the medical board's office in Sacramento. All written testimony must have been submitted by the deadline mentioned above. 1 written comment was sent in support and 1 letter of opposition was received. To ensure fairness and that everything is entered completely into the record and to enable everyone to hear those who are giving testimony, we ask that those testifying follow these procedures. Speak loudly and clearly. Identify yourself and who you represent. Please state your position, support or oppose, at the beginning of your testimony. Oral testimony will be limited to 5 minutes per person. And if you can, please do not repeat testimony already given. Any written comments you have with you today should be summarized orally, but should not be read, if you don't mind. After our legal counsel's opening statement, I will call on those persons who want to testify. Our legal counsel, Ms. Webb, will be assisting myself, the board, and the executive director in this process. Ms. Webb, do you have any comments?
I think I'd like to begin by inviting those who wish to speak on the proposed amendments to come up, and then we can proceed with our discussion thereafter.
A point of clarification, I need to recuse myself from this discussion. I've recently been appointed to the board of IMQ, the Institute for Medical Quality, and this is an issue of interest for them, and so.
All right, thank you, Dr. Levine. All right. Now I will call on those persons who wish to testify concerning this proposed regulation. The first person who signed up to testify is Yvonne Chung. Good morning.
Good morning. CMA has submitted written comments, which are included in your agenda materials, so I will briefly summarize those. We are supportive of making high-quality continuing medical education accessible to physicians. We believe that CME is an important tool for improving medical practice and patient care, and we support facilitating the process by which physicians can complete continuing education hours that can be applied toward the board's licensing requirement. However, we have concerns that the regulations as proposed could potentially result in physicians participating in CME programs that don't meet accepted standards for quality, namely the absence of bias and making sure there are no conflicts of interest in the delivery of that CME. We believe that basically providing a blanket approval and allowing any maintenance of certification activity approved by a recognized specialty board to qualify as approved CME is a risky practice for the board. While ABMS sets CME guidelines for its member specialty boards, compliance is voluntary and there's no mechanism in place to make sure that the MOC activities developed are meeting accepted industry standards for CME. We're not calling into question the reputation of the specialty boards. However, we would point out that as recently as this year, the American Board of Internal Medicine admitted to rolling out a maintenance of certification program that, quote, got it wrong, and they actually pulled it back because they realized it wasn't meeting the needs of physicians. Many educational institutions and healthcare systems like Stanford and the Mayo Clinic that are very well regarded make it a point to accredit their to become accredited and offer certified CME because they see the value in making sure that there is basically a third-party check to make sure that the quality is there. Therefore, we urge the board to reconsider these regulations and require that the MOC activities that are being used to meet the CME requirement meet accepted standards for CME as they are today. Thank you.
Thank you. Are there additional comments from the public? I see no additional comments. Are there any comments from the telephone?
Do you have any public comments?
No comments from the phone at this time.
All right, thank you. Ms. Webb, if you don't mind, can you outline the options available to the board with respect to...
Can we close the hearing?
Oh, yes, let's close the hearing. I apologize. There is no further comment or testimony. It is therefore closed. Now it's up to the board's pleasure to make a decision. Ms. Webb, can you outline some of the choices available to the board in consideration? Thank you.
As the members know, this proposed amendment to the regulations came about following a presentation from Carol Clothier from ABMS. And the options for the board, in light of the testimony and concerns expressed, are to either proceed as is with the current form of the rulemaking file. You could also move to withdraw the rulemaking file indefinitely, and if for some reason the issue comes up again, it can be reintroduced. Or you could instruct staff to renotice the rulemaking file with additional information. Some of the concerns that CMA expressed in the written argument was based on estimates provided by staff, and that's all staff has to go on are estimates. There's not hard and fast numbers related to what the cost savings to physicians will be or what the cost to CME providers would be. So there's not going to be solid numbers to base this on. So with that, those are the three options. Staff would need a motion in the board's direction on how you would like us to proceed.
All right, thank you, Ms. Webb. Dr. Lewis?
Yes, thank you. I've been following this MOC for quite some time, and as was mentioned by one of our person from the CMA, that this program has now been, from what I understand, been pulled back. And the quote from the president of the American Board of Internal Medicine actually says, "We got it wrong and we sincerely apologize. We launched programs that weren't ready and we didn't deliver an MOC program that physicians found meaningful." So I'm wondering, and I'm going to ask Ms. Webb, is that this may be too premature to proceed on this, and whether we should just pull back until the American Board of Internal Medicine sort of gets it right and rolls out a program that they think is meaningful that we can review properly.
That's absolutely an option, and the board is authorized to create different pathways to fulfill CME requirements. And if this isn't the right time to do it for MOC, then we can pull it back and revisit it at a later time.
Dev?
I went through this very carefully. I think almost every board, it's not just the internal medicine is the only one who said they have issues and they got it wrong. But surgery boards, family medicine boards, everyone is doing a maintenance of certification. Personally, I have 2 boards. I got to recertify. I used to have 3. I finally gave up one. I getting tired of recertifying every 10 years, means every 3 years you get a board exam to take. So So you do, I mean, you study, you follow the maintenance certification protocols, and it's a fairly decent CME. I understand that sometimes I feel like it's a food fight between AMA and ABMS, and the doctors are left in the middle. Why? It doesn't make sense to me when you have an established entity like ABMS, established maintenance certification requirements we follow because we want physicians to be board certified and continue to be certified. So I don't see a reason why we shouldn't be accepting the CME basically through MOC. I have a tough time really getting it, so that's why I'm just expressing my feeling as the one who goes through these CMEs and board exams, and I see also a lot of other people doing the same.
Thank you. Dr. Bishop?
I certainly respect Dr. Lewis's comments. You know, when somebody gets it wrong, you don't want to take a lot of stock in that. However, by not creating these regulations, I think we might be unfairly penalizing people whose boards have gotten it right. And there are people who, as Dr. Gondiv says, may be doing CME this is very, very relevant and helpful, and they should receive credit for that, I think. So I think the greater good for the greater number suggests we want to consider this strongly.
Thank you, Dr. Bishop. Dr. Kraus?
We require CME because we require physicians and surgeons licensed in this state to remain current. The whole purpose of the Maintenance of Certification program is to have physicians and surgeons remain current. It seems appropriate that the hours spent in studying for maintenance of certification would be acknowledged by the medical board as appropriate CME credits.
Are there additional comments or observations from the board? I see none, and I don't want to summarize. We've got a small sampling, but some very good comments. It seemed to be proceed as is. There are three options that Ms. Webb outlined for us: proceed as is, withdraw the file, or renotice with additional information. I'm not lobbying for anyone in particular, but I am trying to motivate a motion.
Yeah.
Yes?
I make a motion to proceed as is.
Been a motion and a second. Are there comments from the board members on the motion? Yes.
I think, though, there is some concern about that was raised by CMA in terms of the information that staff transmitted in there, and that there may be some errors, and I would be concerned about moving forward on a regulation based upon what could then have been challenged later as faulty information. So I would ask that perhaps maybe we could, I don't know, table this so that we could get verification of the information. So as we move forward as a board, that regulation is clear and clean.
So the faulty information that was provided was pertaining to the cost of what the CME is and the cost savings. This, while that is important information that has to go into a regulatory package, that is not what the reg package was hindering on. We can go back and work the numbers because that's part, it doesn't have to, we may have to renotice that section for the economic evaluation, but even if we change that, it wouldn't change the regulation in and of itself.
No, I understand that, but I think if the premise is that one of the reasons this is being brought forward is so to increase access and to make it affordable, I think, it is misleading to characterize that the CME is $200 a credit. They're not. I mean, I just went online, you can get a batch of them for $69. So I think that we, need, and also as a member of the public, I would be concerned this board not support anything that lowers the bar for the requirements for continuing medical education. I think in these days of really increasing technology and complexity, what we want is our licensees to actually strive for the highest level of continuing ed. And quite honestly, as an attorney and as a nurse, our requirements are much higher. So I would hope that we would hold all the professions to the same level.
I'm looking to my right. I'll go Ms. Yaroslavsky, Dr. Kraus then.
I have a question more on clarification than anything else. I understood that this regulation was to allow the continued specialty boards to provide the appropriate CME for their board certification for MOCs, and that is all that this is doing. So I'm not quite sure why, if the Board of Internal Medicine has figured out that they've done something wrong, why it's not their responsibility to fix that part versus the regulation process to fix it. So I'm not sure where the barrier is to moving forward with it as stated, and as they go along to fix it, and if there's a money issue. I'm not sure why that's part of this. So just point of clarification, if you could explain that to me.
Dr. Kraus? Oh, I'm sorry. Comments from staff.
So the regulation, when we heard from Ms. Clothier from ABMS, each maintenance of certification program, and those of you that have done it, it can correct me if I'm wrong, but they each year they have to do 25 hours of CME in order to continue in their maintenance of certification. The medical board also requires 25 hours of CME for license renewal. The problem is that some of the CME that they do in maintenance of certification, am I wrong?
It's 50 hours in a
For
two-year
renewal,
period.
that's right, it is, yes. But so the hours that they use for maintenance of certification, our requirement is that they're Category 1 CME or that they are approved by the American Family Physician. So those are the two things we accept. What the maintenance of certification accepts aren't always Category 1 CME. So this would be authorizing us to receive, just as long as they meet the maintenance of certification, it would be allowing them to accept those as long as they've met MOC as counting as our required renewals period. So that's the difference. And where the cost comes in is with any regulatory package that we have to put through the Office of Administrative Law, we have to show how much it costs to everybody. And so in this regard, when we looked at this, we said, okay, is it going to be an impact to the physician? And we went, as you can see in the, and it might not be correct, again, we were doing assumptions from staff's perspective, CME costs all the way from free all the way to like $1,600 for very involved and very convoluted CME. So we looked on average, it was about $200 is what we had seen on average, and I know that people are saying now that that's probably not right. It might be about $60 maybe on average, and we can go back and work that. So we said, okay, how much is it going to cost the physician to not have to take these additional CME? And we averaged about 12.5. We said about half of them they could do that would be Category 1 and half that wouldn't. So then that's the amount that we used to work that out. And that's probably about right for half of the CME that they would do that would fit in and what that wouldn't be. And so that would be the cost savings for the physician not to have to duplicate it. On the same hand, there is an impact to business, and that would be the businesses who perform the maintenance or the CME themselves. And so then we said that's how much times the population of physicians that they would lose in revenue that was coming in. So as one goes down, as the maintenance of, if we took the CME that it's going to cost the physician down, that's also going to take down what the impact would be to business. So that's going to remain the same. But so that's what this regulation would do. And again, it's up to the board.
I got it. Dev?
Just a point, and then I'm okay with certain things. The point is that the CME requirement for a maintenance of certification is a lot higher standard than what some of the CMEs offered through the standard CME process. So if anyone else thinks that CME is somewhere lowering standards, that's completely wrong. Actually, you can take any CME. A surgeon can go on a cruise and take a psychiatry CME and be certified as CMA PRA1. So that's not the issue. But if staff feels that because of the cost, what they came up with is wrong and it needs to be revised, I'm okay with tabling it, because we don't want wrong information to go. But as far as the board quality of CMEs, they're at least equal quality or a higher standard. So if staff wants to come back, I don't have any problem. I can withdraw my motion and go for table for the staff to come back.
Thank you for that. I was thinking this, I think we were all sort of maybe thinking the same thing. We want the record to be full and complete and as accurate as possible, therefore not subject to any sort of legal challenge. So is your motion then to renotice with additional information?
Yes.
Thank you.
Second that.
Second. We have a new motion. Discussion. Dr. Kraus?
Is this table motion to time definite?
I'll ask Ms. Webb to speak to that. It's not a table at the call of the chair. It's more of, well, I'll let you talk.
So what would happen under normal circumstances with a normal regulation package, when we have edits to it that have been brought forward by interested parties, we take those and we will renotice the regulatory package for another 15 days. So we would go out for another 15 days. What we would put in is then the motion would be that we'd renotice it with the correct information in it. Then if there are no negative comments, it would.
We keep saying correct information. This is all based on estimates. And
thank you
there's
for that.
still going to be, someone will likely still raise a
I
concern.
appreciate that. That was a subjective word. I didn't mean.
Me too.
Yeah.
So the new information that we would provide into it, we would renotice it. It would go out for 15 days. If there aren't any negative comments, we would continue to process the regulation, because again, the changes aren't with the language, it's with the amount of money. And so we would change that. Or if there are negative comments, it would come back to the board at the next board meeting for another vote. That's how all of our reg packages process.
Would that, there's no interested parties meet?
No.
Okay. Is that your,
Yeah, I'm good with it.
okay. There's been a motion and a second. Discussion on the motion. Does that answer your question, Dr. Kraus?
Yes.
Okay. I see no further comment from the members. Are there any public comment on the motion to renotice with additional information as described by the executive director? Are there any comments from the phone?
No comments from the phone at this time.
Thank you. Ms. Toof, please call the roll.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Aye.
Dr. Levine?
I'm recusing.
sorry.
Abstain.
apologize.
I'm sorry, recuse.
Dr. Lewis? Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
And Mr. Serrano Sewell.
Aye. Thank you, members. We'll now move to item 22, discussion and possible.
Pardon me.
Oh,
Forgive me, there's two other pieces that I would like to make sure we're clear on. The first is CMA did propose an amendment to the language, and I want the board's vote that the board rejects the proposed amended language, because it really would nullify the purpose of the regulation. And so I want to know that we're comfortable going forward with the draft that staff prepared. May I have a motion?
absolutely. Is there a motion?
So moved.
There's been a motion and a second. Is there a second?
Second.
Second, thank you. Are any public comment on the motion? Seeing none, or is there comment on the phone?
No comments on the phone at this time.
Ms. Toof, please call the roll.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Aye.
Dr. Lewis?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Mr. Serrano Sewell.
Aye. Okay, that motion carries. Ms. Webb?
The other piece is that if we renotice the regulatory package with amended economic information, and there's no negative comments that relate to the substance of the information, that the board authorizes staff to make any non-substantive changes to the rulemaking file and to proceed with presenting it to the Office of Administrative Law for approval.
Second.
There's been a motion and a second. Is there any discussion on the motion? Seeing none, any comments from the phone?
No comment from the phone at this time.
Thank you. Ms. Toof, please call the roll.
Dr. Bolat? Aye. Dr. Bishop? Aye. Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Aye.
Dr. Lewis? Aye. Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
No.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Mr. Serrano Sewell?
Aye. Motion carries. I think, does that conclude? Does?
That concludes this agenda item.
Thank you. Thank you for your help, Carrie. It's much appreciated. And Ms. Dobbs as well. We'll now move to item 22, discussion and possible action on interim suspension orders. This will be a joint presentation from Ms. Kirkmeyer, Mr. Gomez, and Ms. Castro of the Attorney General's office. I had asked staff to put this agenda item on for discussion and possible action today. During our legislative meetings and also meeting with consumer groups and other interested stakeholders, there were concerns about the length of time it takes to issue an interim suspension order if an individual is deemed to be a danger to the public. I asked staff to look into this and to begin a discussion on that process. I strongly believe that the board should adopt a resolution indicating how important these suspension orders are in protecting the public and providing some guidance to Ms. Kirkmeyer to work with the Department of Consumer Affairs, Mr. Gomez's unit, and the Attorney General's office in tightening those ISO timeframes. That is the purpose of this discussion item and possible action. Ms. Kirkmeyer?
I would like to draw the members' attention to tab 22 or BRD 22-1 and 2. In this memo, I've outlined the process for obtaining interim suspension orders. This process allows the board to either suspend or put restrictions on a physician's license prior to disciplinary action being taken for cases where a physician is an imminent danger to the public. However, the issue that we all run into is the fact that an accusation needs to be filed within 30 days of the issuance of an ISO, so the investigation needs to be complete. Mr. Gomez, Ms. Sweet, and Ms. Castro will speak to their specific role in the issuance of interim suspension orders, but as I stated in the memo, we plan to really review cases where ISOs are either issued or denied and determine ways to expedite these cases. I believe Ms. Sweet has already begun looking at the cases that we've basically issued in the last year, actually a couple years now, and that so we can I'll hand off the discussion to her to talk about what she's been doing, but we will, and as you can see in the request to the board, we really want to look at each one of these cases on an individual basis and see where the stalls were, what happened with these specific cases, why did they take so long if they did, because some of them obviously an average you have to have low and high, and so the ones that aren't an issue we won't look at those, but the ones that seem to be a problem and taking so long we want to really investigate those and see if we can find methods and ways to expedite the time. So I'll hand it off to Ms. Sweet.
Thank you, Ms. Sweet, for working with me and Kimberly in this presentation.
Absolutely. I'm very pleased to have had the opportunity to review this issue because a 3-year average of about 355 days from receipt of a case to issuance of an interim suspension order is not acceptable. In preparation for this meeting, I reviewed over 10 cases that resulted in ISOs. That took longer than 1 year between assignment and filing. Of these cases, the majority of them involved mental or physical impairment, including addiction issues and overprescribing. Several of these cases involved prosecutions by the federal government. In many of those instances, we were not able to pursue PC-23s, which is another mechanism to intervene on a physician's practice, because they were federal and not state matters, and PC-23s, which stand for Penal Code Section 23s, can only be sought pursuant to state law. Another issue is that once an interim suspension order is filed, because it is considered extraordinary relief, the Office of the Attorney General has to be prepared to file an accusation within 30 days and put on a hearing within another 30 days. In cases where we are awaiting a federal conviction, this puts us in the unenviable position of having to wait For purposes of what constitutes a record of conviction in the federal courts, we are required to obtain the sentencing documents, and that can often take up to 1 year in the federal system to actually get the sentencing information. Ms. Castro and I met last week to discuss these issues, and we're going to be working together to see if there are alternatives to proceeding with these cases absent the document supporting a conviction. There have been situations where the Attorney General's office has worked with the federal prosecutors to get a stipulation relating to suspending practice, so that's positive. Similarly, another issue that we've already addressed was the problem of when the DEA or another agency was jointly working an overprescribing case with us. During 2013, we changed our practice of standing down at the request of an allied law enforcement agency unless the practitioner's DEA license could be suspended or we had assurances that the case would not languish. For the most part, this has been received positively, and cases with allied agencies are progressing much more rapidly. Another issue that used to impact aging that we addressed in 2013 has to do with medical records. Many overprescribing cases get bogged down because of subpoena enforcement actions, which, as you know, can add over 1 year to a case. Because prescribing without a legitimate medical purpose is a crime, until proven otherwise, all allegations of overprescribing are now handled in the criminal arena. So when probable cause is established that conduct is criminal, we can proceed with a search warrant rather than engaging the subpoena process, which is significantly faster. As for the other cases more likely to result in the issuance of an ISO, mental and physical impairment cases, we identified several areas where we can improve timeframes. And again, Ms. Castro and I met last week and discussed this issue at length. We will both be working with our respective staff to expedite the handling of these cases. For HQIU, I am prepared to recommend some policy changes in order to make sure that investigators are making contact with subjects within a very short time frame when allegations of impairment are set forth. Also, oftentimes an allegation of mental and physical impairment accompanies a quality of care allegation, and the investigator has been directed to work both issues up, and the AGO does not move forward until the case is completely done. And Ms. Castro and I agree that from now on, we will first rule out the mental and physical impairment issue without waiting for the quality of care component to be resolved. And this will enable us to request the physician be examined, and if they refuse, move forward with a petition to compel an examination if the evidence supports this. And this can usually be accomplished within 60 days. Lastly, there's a huge learning opportunity for investigators and attorneys in merely reviewing these cases and doing post-mortem, so to speak, on the investigation and prosecution. And we have discussed doing this for a while, but now would be a good time to implement, without fail, a review of every case that results in a request for an ISO, whether or not it is issued or denied. Each case can be reviewed by involved staff and independent staff to critique the progression of the case and determine where time may have been lost, or ultimately and ideally that the case was handled perfectly. I want to thank Mr. Serrano-Sewell and the board for bringing this issue to our attention, as I am confident that we at HQIU, working with the Office of the Attorney General, can make a measurable difference in reducing the time it takes from the time a case is received to the time an ISO is issued.
Thank you, Ms. Sweet, for that report and already the collaborations that are happening. I appreciate that. Ms. Castro?
Yes, good morning. Thank you so much for having us look into this issue. My meeting with Ms. Sweet was very positive last week, and I wanted to just add some more insight from the Attorney General's office. Our discussions prospectively should also include a better assessment of how to measure that, how long an interim suspension order took, and to also look at results, though. We're very results-oriented. We want to make sure your money goes as far as possible. And so we file cases that will result in a win via an ISO, a full shutdown, or sometimes even settling for a partial restriction. What this means is ordering drug testing, ordering chaperones in sex cases, and things less than a shutdown that accommodate both public safety and the physician's continued practices. I also wanted to point out that in this calculation, what is sometimes not counted is when the Attorney General's office is able to obtain a stipulated ISO. It helps the physician be taken out of practice very quickly and effectively so that he or she can deal with his or her issues. This is most common when there is a substance abusing physician that needs to get some help. And on that note, the most serious of cases are also filed as ex parte ISOs, and that will obviously add in some time because we go in without notice to the respondent, but if we can get an ex parte ISO, we do. And those are the most extreme cases. We should also be reviewing cases where we were not successful in obtaining the ISO. I really firmly believe that we can learn from our mistakes, and that is the point that Ms. Sweet wants to make as well on the postmortems. And in any event, even a failed ISO is always a filed accusation, and we always try to set those for hearing as soon as possible. It would be important to identify outliers so that you can get a true picture, and I would definitely encourage the discussion to include determining what the mean picture is, and maybe weeding out criminal cases as outliers and calculating how long ISOs take when we're waiting for another prosecuting agency to go first. It is important to note that based on case presentation itself, we cannot not always identify an ISO when it comes into Ms. Kirchmeyer's office, when it comes into Mr. Gomez's office, or even when we get involved. There are many different steps to an investigative process, and sometimes interim and suspension order cases that are urgent are not identified until the medical consultant reviews it in the field, sometimes at a subject interview when the subject shows up, or even when the expert identifies something that we all missed up until that point. So I just want to make sure that you realize that as soon as we capture the fact that this is a dangerous physician that should not be practicing because they pose danger to themselves or public health and safety, that we move forward. Therefore, there needs to be cooperation, obviously, between my office and HQIU to elevate formally routine cases to urgent cases when ISOs are identified. And I would recommend for certain that SOUP 1s and SOUP 2s from HQIU start attending ISO hearings from now until October. So then that way, Ms. Sweet and I can definitely get a full spectrum of what the experience is, and we can have that aha moment together. Because we agree that this is a very important issue. I will also want to point out to the board that there will always be issues outside of your control as the medical board. For example, you cannot control whether or not an expert that we retain to tell us whether or not a physician is dangerous or not is going to also be available for this expedited accusation hearing. In the sense of a full shutdown, physicians want a speedy hearing. And so they are entitled to have an accusation heard. So when we pick our experts, sometimes we have to say no, even though they could provide the opinion in a timely fashion, because they will not be available within 90 to 120 days when we believe we might be going to hearing. So we really have a lot of difficulty doing that, but we just really need the same expert that said this person was dangerous to testify at the accusation. And this is all for due process, obviously. Investigations do almost have to be complete. This is for the respondent's benefit. Obviously, the respondent should know all the evidence that we have against him or her. And because of that, we really have to move these cases, and sometimes it's not possible to file an ISO any sooner than being able to provide physician with due notice of what the charges are and what the evidence holds. With respect to OAH, I can tell you confidently that we'd never have any issues setting an ISO with OAH. Well, we have had some issues in the past in some of the offices in getting the response back from OAH. And so we've been working on that. We're excited to see that there's a new head of OAH, but there have been issues with waiting to get an order back. And sometimes in the sense of an ex parte ISO, if it's taking longer than 2 weeks and you haven't heard on an ex parte ISO, we usually just take that as a hint and just move the case along and file an accusation, thinking that perhaps we're not going to get our ISO. Sometimes, in one particular case that Ms. Sweet analyzed, our DAG did not even find out that the respondent was subject to federal criminal proceedings and that he had been sentenced. This was a month before his trial. And there had been a full and complete shutdown of exchange of information between the medical board and the feds, but I think that Laura Sweet has mentioned that that relationship is on the mend and that should not reoccur. But that was pretty crazy to find out that he had a federal sentence hanging over his head a month before we were set to have a hearing. and DAG Larry Mercer filed that ISO within 4 days. In 820s, these are the mental and physical examination cases. We have to invest time to get a petition for an ISO. And so I agree with Ms. Sweet that to the extent possible, we need to rule those out because that's the lowest hanging fruit, and that is actually what helps the physician in addition to his patients. We could also focus on more expert training in that arena. In PACE failure cases, in probation cases, the medical board aptly sees those as immediate ISO suspensions. If a PACE is a condition precedent and you do not pass PACE at UCSD or any similar program, you are automatically a danger. However, those expert reports sometimes have multiple conclusions such that we cannot identify an ISO with confidence that we think that we might be able to get that ordered by a judge. And in those cases, we attempt to file a petition to revoke probation as soon as possible. And I already mentioned that many times our office obtains stipulated ISOs. I don't think those are usually counted in these averages because even before it's even filed, opposing counsel and respondent come in with open hands and they just want to enter a stipulated ISO. We send those to Ms. Kirchmeier and she processes them as quickly as possible. So we look forward to giving you a full report in October 2015, and I look forward to working with Ms. Sweet.
Thank you. Dr. Lewis?
I'd like to make a motion that directs the executive director to work with the Attorney General's office and the Department of Consumer Affairs to identify strategies to expedite cases involving a physician who, if permitted to continue to practice, will endanger the public, and to issue an interim suspension order as expeditiously as possible, and also to request a report on these strategies at the October 2015 Medical Board meeting.
Second for Ms. Thank you, Dr. Lewis. A second from Ms. Yaroslawski. Any questions or comments from the members? It's an important tool. Yes, Ms. Yaroslawski.
So I would just like a point of clarification on situations where other law enforcement entities are involved. I understand that that's always been a barrier to time process. We have mandatory reporting in so many different areas when a respondent comes before the courts, when it goes. Is there any way to expect mandatory reporting from federal officials so that at the beginning of the situation that at least the appropriate state of California entities are in the loop of what's going on? Do we do that now? Could we do that? Should we do that?
What you're describing almost sounds like you would want to know when the doctor's arrested.
Yeah.
And so we just went through the internet posting regs, but that would be what, 2007? But no, federal agencies and any prosecutor/investigative agencies would not want to post anything there because then respondent knows about the criminal investigation.
It's not so much the
before it's
posting.
filed.
If a doctor goes into court, is arrested for something, the court clerk has to report, the district attorney has to report, the city attorney has to report, everybody has to report.
An
But I'm not
arrest.
hearing that any federal entities have to report. So I'm asking, is that a tool that would be helpful to being prepared to be ready?
I think any opportunity to intervene and be aware of information is always a great idea. But typically where we're having the issue, it has to do with we're aware of the case, but we're working jointly, and then other agency has taken the lead or wants to be the lead, and they want to do undercovers, and they maybe have a different burden than we're used to, so they tend to take a lot longer. So what we've just had a zero tolerance saying we cannot wait. We will give you 30 days, otherwise we're going to move forward because you have to accept responsibility. If you're willing to accept responsibility for what happens, this is kind of how we've approached it. So I'm not sure. I think it would be helpful, but I think the major issue we're having is when we're already aware of it from the federal agencies and it's just not progressing rapidly enough for our liking.
The other issue is that we tend to mirror the discipline/remediation that is imposed by other states. Could we not use that technical skill set to do the same as to mirror or to deal with the situation as it's coming forward from other non-participatory entities, that you're not getting as good a response in a timely fashion?
Prosecuting agencies are just not going to be subject to the Consumer Protection Enforcement Initiative at all.
Okay.
And so each county has independently elected DAs that are going to proceed.
I was
on the
talking more on the federal level.
Oh, federal level. It even becomes more difficult. I mean, we can't even do it with the state. So doing it with an AUSA would prove exceedingly difficult. And one thing that I think we've noticed is that these federal cases are multi-doctors and multi-level. You know, there's billers, there's PAs, they're usually very, very heavy-duty investigations. It's either pattern or practice or very huge impact. So there is a chilling effect, and we do want to operate in tandem with our partners. But I echo Ms. Sweet's strong deterrence to wait too long. Yeah.
Thank you. Ms. Castro, I understand the law enforcement and criminal activity issues. My concern is mostly on the physicians who are harming the patients. How can we get the ISOs quicker on these people? Law enforcement issues are totally different. Our issues really should be the quality of care and actually patient harm. So that I haven't heard how we can get faster ISO on those people.
I think Ms. Sweet and I share the commitment that we will elevate that to the highest level and throw as many resources as possible. I don't think we've been paying attention to that, to take away a case, maybe give it to somebody else that can handle it. We try to do that in our office. We use our lead prosecutors, but perhaps Ms. Sweet can think about a different investigator on a case to help which or we already co-assign. do. We already reassign, so. But what we are doing too is offering up overtime where we see a situation. And I think it's very important for there to be collaboration with the Office of the Attorney General from the outset in identifying these cases and resolving disputes, which we'll talk about in the next presentation, very expeditiously. There's like a zero tolerance for any time period to elapse to resolve a dispute. And I think that's going to help this issue also.
The board recognizes that quality of care cases are challenging regardless. We still think we should proceed on them. Should the ALJ's office continue to not issue those because that's their preference, well then there needs to be changes on that level. Dr. Levine?
I just want to commend you for this work. I think it's terrific, and I think there is probably a tremendous amount of learning in the 100% review of cases, whether or not it's granted. And you know, it's a great example of a quality improvement effort that I think will yield tremendous information for you.
Absolutely. And the collaboration is appreciated. Thank you. I have one comment, public comment card from Yvonne Chung.
Good morning, Yvonne Chung with the California Medical Association. We'd like to say that we applaud the board's efforts to look into this area more closely. We have found it very difficult to get information about ISOs as well. A couple suggestions as you look at this study. We would also be interested in looking at situations in which the medical board could consider using other methods of immediate suspension other than ISOs. I think this goes to Dr. Ganadev's point that sometimes there are, you can do a temporary restraining order, taking a look at the cases and seeing if there were other mechanisms that could have been pursued that would basically result in the same action, which is suspension. We'd also like to look at an evaluation of instances in which ISOs should not have been sought, and perhaps that those resources could be freed up to pursue more viable cases. And in our own research in this area, we have also found it difficult to get a breakdown of, step by step, how many days it takes between, at each stage in the case, including when it gets to the ALJ level and how many days it takes to schedule. So getting down to that granular level of detail, I think would be really helpful. So including a data component with a breakdown of the type of cases, I think would be instructive for everyone. Thank you.
Thank you. I have no additional speaker cards. Are there any comments from the telephone?
We have no comments from the phone at this time.
Thank you. Ms. Toof, please call the roll.
Aye. Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis? Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Juraslovsky?
Aye.
Mr. Serrano Sewell?
Thank you, colleagues. Motion carries. We'll now move to the next end. Thank you, Ms. Sweet and Ms. Castro, Mr. Gomez. Greatly appreciated. Item 26, discussion and possible action on approval of multi-skilled medical certificate. Oh. Oops. Sorry, gang. We're on 23. Sorry, Ms. Sweet. How are you? We're going to be on 23, investigations and vertical enforcement program report. Good afternoon, Mr. Gomez.
Good morning.
Oh.
Good morning.
Is this live? Good morning, Mr. President, members of the Medical Board of California. Michael Gomez, Deputy Director for the Division of Investigation and Enforcement Programs for DCA, assisting on. Wanted to provide the board with a brief update on the enforcement program of the Health Quality Investigations Unit, where we are today. We are now in the 10th month of the transition, and with the exception of staffing issues, our operations are starting to stabilize. We continue to have challenges that are somewhat cyclical with respect to recruitment and retention within the Health Quality Investigations Unit. Currently HQIU has 13 vacancies, and we're projecting additional vacancies that are largely attributable to transfers to other state agencies and transfers and offers from local agencies on individuals we have hired. Currently, we have 4 vacancies were results of retirements, and then the 2 of the vacancies were results of internal transfers. And based on those internal transfers that we started seeing that we weren't getting backfills for the Health Quality Investigations Unit side, we began to stall and not permit any internal transfers until such time we get actual positions filled on the Health Quality Investigations Unit side. We have halted, the remaining vacancies are due to employees leaving, again, for higher paying jobs. And getting back to what I mentioned at the last board meeting regarding that we cannot compete with other agencies in many cases for compensation and other benefits, that during the past 2 years, and this isn't as a result of, if you recall, the downturn in the economy, that NBC hired 17 individuals who had been laid off or threatened to be laid off by the Department of Corrections. The state rules, the SROA rules, require that we must entertain those state employees before we hire any outside non-state employee into the civil service ranks, and that impacted HQIU greatly. One of the things I want to bring to your attention is that it's somewhat frustrating for Deputy Chief Sweet and I to deal with this matter, because we and the medical board have put quite a few people through an academy over those years at a cost of about $50,000 each. When you look at their salaries, the travel, the cost of the academy itself, and the downtime that we experience in terms of just working casework, case flow, that it impacts our casework and the case aging in our Health Quality Investigations Unit, not only at the medical board when they were there prior to July 1st, but it's continuing to do that where we are now. The other thing that we are now experiencing is that local governments are tending to really starting to recruit our own people. And we hadn't had that happen in the past. We just had an individual that retired from San Jose Police Department, came to HQIU San Jose. We had him for 3 weeks? Had him for 3 weeks, and a local district attorney's office offered him substantially more money. And it angered me to some degree, but I think I have to get used to this, is that they are recruiting our people, not just HQIU, but across the board for that, for the talent and for the scarce, and I'll use the term, the scarce availability of qualified candidates for these positions. So we are in competition, and we are looking at challenges to fill our vacancies. And what we have done in the last 4 months is we've focused our recruitment efforts in basically 3 areas. We are looking now at the 1937 retirement counties that, and hate to say it this way, but individuals who can start a second career by coming into CalPERS. We've also looked at the academies who are sending people through who are not affiliated with any agency. And then we're also looking at going to the community colleges and the colleges themselves that have criminal justice programs to recruit those students into our ranks. And as Kim will know, that when we do that, we have downtime by sending people to a law enforcement academy as well. We have had some successes with respect to getting some of our policies and procedures together. We're still in the transition of that, so there is still some instability in that respect. I wanted to announce that we also, I'm pleased to announce that we, since the last board meeting, have promoted Ken Buscarino, retired LAPD supervisor, to the Glendale Supervising Investigation position effective May 1st. And Ken, are you here?
Yes.
That is the man back there. I'm also very pleased to report that the Department of Consumer Affairs and the Office of the Attorney General were successful in completing the vertical enforcement joint protocol draft, which is now being reviewed by the Attorney General. And I believe, and I think Ms. Castro can probably speak to this later, I think we're looking at a projected date of implementation of July 1st of this year to implement that protocol. I believe that this protocol, this manual, is significantly more understandable. It contains timelines and deadlines, if you will, reporting timelines that we can all live with, that I think will improve the efficiency and effectiveness of our investigative partnership in protecting the consumers of California. So with that, I'd like to provide the board with some statistical information, easy to say, right? Statistical information, and I'll turn this over to Laura.
So I would like to begin with the same caveat that preceded last quarter's presentation, and that is, because we still can't extract accurate reports from Breeze, that this data has not been verified, it has not been vetted, and it includes all cases that HQIU investigates, so physicians and surgeons as well as allied health individuals. We still cannot get accurate closed case age cycle times, so what I can provide you today, as I provided at the last board meeting, are open case age averages, and this data is maintained by our supervisors once we converted to Breeze back in October of 2013 now, is it? We, as a kind of a stopgap and safety net, started inputting data ourselves in the event we had glitches with Breeze, so that's proven to be was a very valuable exercise. So the first chart up here depicts open cases over 550 days old. In June 2014, 1 month prior to the transition, we had 74 cases over 550 days old. A year ago to date, there were 68 cases over 1 year, and at the last meeting, we had seen an improvement and we're at 65 cases over 550. And currently, we are showing an increase at 93 cases. I didn't want to change the criteria that I had used for comparative purposes from the last meeting, but I did manually count out which of those are physician and surgeon cases, and of those 93, 78 of the 550 are PNS cases. The second chart depicts open cases averages over 1 year old. 1 month prior to transition, we had 229 cases over 1 year. A year ago to date, we had 207 cases over 1 year, and at the last board meeting, we had 263 cases over 1 year. Currently, we have 285 cases, and of those, 245 are physician and surgeon cases. And this is a breakdown of the progress each individual office has had with cases over 1 year old. So we had another competition calling for offices to reduce cases by 25% since January. 3 of our offices were able to meet that pretty hefty challenge. This is there's a story with each one of these offices, and the offices that are showing the increases, for example, San Jose currently has two vacancies and 1 person just about ready to go. So most of the offices, with very few exceptions, that are showing the increases are the offices that are suffering from staffing shortages. And as for productivity, we are showing an increase in criminal cases by 7, and the remaining categories reveal decreases. So undoubtedly, the question in your minds must be, why are these increases in case aging and decreases in productivity occurring? And I attribute 4 causative factors that I'd like to list in order of severity. The first and most critical issue we are facing, as Mr. Gomez mentioned, is staffing shortages. Last year at this time, we had 7 vacancies, including 2 supervising investigator 1s. Currently, we have 13 vacancies, 1 of which is a supervising investigator 1 and 1 is a supervising investigator 2. And this is despite unprecedented recruiting efforts and continuous interviews. We've been doing about 1 to 2 interview panels per week. We have interviewed no fewer than 75 candidates since the last board meeting. We've revised this brochure that we've been handing out at recruiting fairs. Our staff have been participating in recruiting fairs. They've been getting out there talking to people, so everybody's working very hard to address this particular issue. But it's very harrowing to be working so hard, and then we put people into background, and as Mr. Gomez mentioned, the 1 candidate was here for 3 weeks and he left. Recently, we finished the 6-month background process for another candidate in our San Jose office, and at the time we were negotiating a start date, she received another job offer that paid more. So this is just very disheartening. So we are also anticipating numerous additional vacancies because these individuals we hired from the Department of Corrections are now getting their jobs back. So the Department of Corrections is offering them more money, so naturally a lot of folks want to take advantage of that. So as a consequence of all of that, I don't expect our case aging numbers are going to make any significant kind of improvement during the next quarter. But I can absolutely commit that we will utilize our resources to work expeditiously on the most serious cases, foremost of which are cases that represent an imminent threat to public safety. And I've also been authorizing overtime to be paid out of our asset forfeiture fund in order for investigators to concentrate on serious cases as well as age cases. And ultimately, I'm hopeful our employees can address pay equity issues via the labor relations and bargaining unit processes. The second issue contributing to the aging problem, I do believe, relates to delays attached to vertical enforcement, but I believe the impending vertical enforcement protocol is going to address many of these issues by setting forth expectations, timelines attached to those expectations, and a clear manner in which to approach disputes, which does not exist in the current manual. The third issue that I think requires mention is Breeze, and staff have had to adapt to an entirely new computer system that is not always intuitive. The ability to assimilate and/or extract accurate data is problematic. Supervisors are having to manually maintain data in addition to updating Breeze, which is time-consuming. And we didn't really appreciate the frustration of a 5-second screen refresh time until you have to visit 6, 7, 10 screens per case. So what used to take 1 minute in CAS can take up to 3 to 5 minutes for Breeze. And when you're dealing with over 100 cases in an office, as supervisors are, this becomes cumbersome and time-consuming. And lastly, I think we have to acknowledge that the transition itself has contributed to the issue. Although much progress is being made, policies are still in flux, and we're still changing forms, and we're navigating and learning whom to contact for what, and gaining familiarity with new processes that will take some time to overcome, especially in light of staff turnover. And I know this is something that time is definitely going to cure. A factor I can guarantee is not contributing to the increased case aging is a lack of hard work or passion for public protection by our staff. Investigators and supervisors are working incredibly hard despite monumental challenges before them, and I could not be more grateful to work with the caliber of people that we have. On a lighter note, we've been having regular meetings and trainings with our medical consultants, which is being favorably received. And this hasn't been done consistently until recently, and it's proving to be very helpful and morale building for our doctors. In February, the executive officer of the Physician Assistant Board came and made an extremely helpful presentation. And at our next meeting, we plan to have representatives from the Board of Registered Nursing, as well as from the Office of the Attorney General to provide training to our medical consultants. And retired annuitant John Harai has been tasked with merging HQIU's manuals with those of the Investigation Enforcement Unit, and that's progressing really well. And the Forms Committee is about 50% finished changing and merging forms, which also has been a large undertaking. So all in all, I believe things are progressing as well as can be expected under the totality of circumstances. And I want to take this opportunity to publicly commend the investigators, supervisors, and commanders for their perseverance. The numbers may not reflect it, but folks are working extremely hard with a tremendous number of obstacles, and I'm confident once we can stabilize our staffing situation, the results will adjust accordingly. That concludes my report.
Thank you, Ms. Sweet. Sure. We usually have Ms. Castro. No, yes, we can have comments now on DCA's report. Yeah, Dr. Bishop.
Ms. Sweet, you know, the key, as you said, is the stabilization of the personnel situation. But from what you're telling me, there's no possibility of that, short of giving these people more money. I mean, is that assessment close?
I think it's accurate. I think that is an accurate assessment.
So I guess where do we go from here? I mean, does the legislature have to step in? Because it's only human nature, obviously, especially in these trying times, to want more money. And so it seems to me there needs to be some direction from people who hold the purse strings to help us out with this, because other than that, we're just barking up the wrong tree.
No, and thank you, Dr. Bishop, for your comment and your question, is that the department is aware of the recruitment and retention issue that we're facing in HQIU in particular. As all of us know, there's collective bargaining. That said, however, is that from the executive office's point of view, we have to take this up the ladder, up the flagpole, if you will, to get executive sponsorship, to get agency and the director and individuals involved, because our mission becomes less than a mission if we can't have the human resources and the individuals to do the work. And that's where we are right now. We are in competition, as I said earlier, within the civil service system of the state of California, and also within the if you will, the market of employment that is now occurring with the peace officer classes. But this is going up the flagpole to the agency secretary and to the director, and so that portion is going to, we're going to push that. That we've got to do something.
It's just that I just wanted this more for the public consumption and also other people listening in. That a year or so ago, we were all under the microscope, and we've done everything we can. I think everyone has, yet we've been kind of ambushed by this one thing. So I think those same people that put us under the microscope would wonder if they could put this issue under the microscope, and perhaps other people would listen as well. Because I mean, I agree. I have full faith and trust in you folks. It's just the exigency of the situation. I think the only people who can change that perhaps aren't even here today. So I think I certainly support you, and I hope the board does too in those efforts.
Thank you, Mr. Serrano-Sewell. I'm at a loss to understand when we were explained that the whole problem 5 years ago was the amount of money that we were paying our investigators at the medical board and retention of those people. we were fed a bill of goods to start rearranging the deck chairs on the Titanic, and we argued that point at that time to be told that there was reason to rearrange those chairs. The Titanic wasn't going to go down. And now today I'm listening to Ms. Sweet, and I thank you for your report, Ms. Sweet, Mr. Gomez, but you know something? It sounds like an awful lot of sugarcoating to say that it's the same as it was, that you're a feeder institution for every other law enforcement in the state of California, and that everybody in the state of California has an appropriate job and has the money that they want to make, and there aren't enough people to fill those jobs that you're offering. So I'm going to tell you that there's no excuse. I'm going to tell you that the medical board investigators, when they were with us, put in time and energy and got the job done, and we never heard about all of this horrible. We heard every week or every meeting that there was a deployment of personnel problem, but we tried to make it work. And what I'm hearing now is that it's even a bigger problem. So we have not only our investigators that have a problem, your whole department has a problem. So I don't know where we're going to go from this, but I'm going to suggest to you, and I'm going to suggest to the members sitting around this horseshoe, that this is not a new story. This is not a new problem, but it seems to be a lot less in the solution department. So I'm really disappointed. And Mr. Gomez, you know I have a reputation of that, so I'm waiting for that remark as well. So I want you to know I'm still there, okay? I'm not happy about this response.
I don't think I am either. I don't think Deputy Chief Laura Sweet and I are happy about the situation either, because we're trying to do our mission, and there are barriers to that mission when we can't get people.
It's sounding like it's all about salary.
Well, I think that is a large part of it, but I don't think it's the only part. We have many investigators that are staying with us because they love the work. They love the work of the Medical Board of California. They love the Consumer Protection Mission. They will not leave for money, but we do have recruitment issues versus retention issues.
Are all of your investigators law enforcement officers?
All of them are, yes.
Is there any discussion of changing that model?
That model has been changed, actually. Under the Consumer Protection Enforcement Initiative, the department received around 48 non-sworn special investigator positions with some of the Allied Health Board, the Healing Arts Boards, RN Board, LVN Board. Pharmacy, I think, received not special investigator series, but non-sworn positions. I know Medical Board received 9 or 10 as well. But remember that the classification and the job duties are a little different. They are a little different, and the training's different, and so that model has been approached, and we currently have that model. You know, we just took one of the special investigators from another board, and they're with HKIU today. So we're recruiting from that pool as well.
All right.
Okay, I'd like to move on to Ms. Shipke's had a comment.
Well, Barbara, I'm going to piggyback on that and echo the concern. Many of us were at this board at the time. First of all, I think the former investigative unit for the medical board is owed an apology, a public apology. We had board members, and thank God they're not here anymore, who would do nothing but humiliate when we would get reports about the same identical reports, actually a little bit better than what we were showing today. The news media jumped on it. The next thing we see is the legislature, which always has a knee-jerk reaction to things without investigating, and they yanked them out of here and gave them to you. And so I think that it is incumbent on this board. We tried to communicate that previously, both to the legislature, but I do think we need to communicate with the governor as well, that there is a systemic problem in the, when our people came to us, said the same thing. We're having a hard time recruiting, hard time retaining. They're not paid enough. There's something going on. We can't do the work because we don't have the staff. So I would hope, Mr. Chair, that somehow this board can send an official message both to the governor and perhaps to the two legislative leaders that this problem didn't get fixed. And it was not because of the incompetency or lack of dedication of the previous people who were in charge of it, but it is a systemic problem. And until we address that publicly, I think what we're going to see, again, we're going to get a continued public chastising about how it takes so long to deal with bad doctors. And so I would hope, Mr. Chair, that somehow we can communicate that, because if these statistics continue that you just showed us, we're in for a real serious problem by the end of this year, even more so. And I don't think the public wants to see that. And again, I don't think any of us on this board wants to see that.
And I appreciate your observation and your comments. I'm in support of the direction of the characterization of what we have. I mean, that is what we have. Earlier I said I've been in this 10 months, and so I'm living the life of what happened prior as well. So, but we want to do some problem solving and figure out how we're going to get there, given the rules and policies that we have as a state of California.
And I appreciate your work, and wasn't to minimize your effort, but I do think, again, Mr. Chair, that we have got to more formalize, in a more formal manner, communicate to the interested parties that we have a systemic problem, and that passing it off and giving it to another entity is not the answer. We've got to deal with the problem. Otherwise, again, the consumers in California are going to be outraged when they find out that we are now getting behind the curve of trying to get these cases investigated.
Here's what I'm going to do. I'm going to ask next time I'm in Sacramento if I can get 5 minutes with the director just to talk to him and communicate the sense of the board to him. With Kimberly, I'll ask Kimberly to join the meeting as well, and anybody else, just to communicate the board's thoughts on the issue. I will say what I've consistently said is, as an arm of the executive branch, we implemented the will of the governor and the legislature and the reassignment of investigators. Those are just simply the facts. And so it's a continual learning process. And thank you for your report. Are there any comments from the public on the report? Are there any comments from the phone?
We do have a comment from Genevieve Clebriol.
Genevieve, do you have any public comment? I don't see any right now. So, Ms. Castro, moving on to item 24. Oh, did I cover everything? Did, thank you.
Good morning.
Update from the Attorney General's office. Good morning.
Yes, I have a vertical enforcement update as well. So good morning, Dr. Hawkins and Dr. Bolat. Welcome to this honorable body. I'm really looking forward to working for you. I'm the Senior Assistant Attorney General of the Health Quality Enforcement Section, and I manage all the attorneys that do the important work that you pursue here in your quarterly meetings. We prosecute the cases. We work very hard. We're not hourly employees, so we have to work as long as possible to get the work done, something that I think you as physicians are totally aware of. Just real quick, like Mr. Gomez said, the draft manual, the draft joint protocol for the vertical enforcement program is in the Attorney General's office and is being reviewed. We hope to have it approved and implemented by July 1st, 2015. And I have had preliminary discussions with Ms. Sweet regarding rolling out the manual to HQIU and HQE staff in tandem city by city. Each city has a different culture and different strengths and weaknesses, and we believe that this is the best way to roll out our manual. And Mr. Gomez and I have been, thinking about different training issues. The cloud continues as a pilot project in the Sacramento District Office and the headquarters of the Medical Board. Because of breeze issues, we have had some delays in the technology contracting process. The hope of the cloud is to eliminate days spent in transporting documents between offices and to provide DAGs a real-time review of cases and evidence. We have had a real impediment in information sharing since the elimination of the CAS system and the implementation of Breeze, such that we cannot see what the investigation status is at any given time. So we have to email investigators or give them calls to obtain statuses on investigations that consistent with our own case review and case management. As you are aware, the transition of your investigations to HQIU has not been smooth, given the lack of the joint manual and also because there's 3 entities involved in the process. At 10 months into this new relationship, we find that we are repeating, unfortunately, some of the issues we thought we had put behind ourselves before. But I have the confidence that we will continue to work together and that the joint manual will make a lot of difference. We continue to reinforce that now that the investigation unit is no longer housed with the client, that there are appreciable differences to be recognized in the process. The investigators should not practice law or attempt to supervise lawyers, and at the same time, the lawyers should direct but not supervise investigations. HQIU and HQE exists to serve you, the medical board, and to pursue public protection, and we both believe that moving cases forward is a shared goal. And like has been already determined, this year is a wash, and we'll start anew on July 1st, 2015. And we want primarily to have uniform enforcement of the vertical enforcement program in both of our offices across the state, and calculated always to maximize your scant resources. The most profound change since July 1st, 2014 has been that HQIU has been unilaterally marking cases for criminal treatment, but not in all events following procedures that were put into place previously by the medical board when you manage the Operation RX and Operation Safe Medicine programs. We need to examine those practices a little closer because I really firmly believe that not all your cases are probably criminal cases, though there are some strong exceptions, obviously in fraud cases and the most egregious prescribing without medical indication. You have the authority, but you should apply it judiciously, given the fact that, as we all are painfully aware, criminal cases can slow down the disciplinary process. And we are administrative attorneys. We do not prosecute criminally. And so we will endeavor to provide you with full legal advice when we first receive cases through our lead prosecutors. And we look forward to managing any Penal Code Section 23 bail restriction recommendations that we can make on cases that are criminal that you are presenting to prosecutors statewide. But at the same time, I'm very committed to make sure to interject our legal opinion and also information to our executive director when we feel that a criminal prosecutor has taken too long to proceed to work up a criminal case. And so we will go ahead and pursue the disciplinary case and put patients on notice. It's very important, as you kind of highlighted, that if a criminal investigation is going on and patients don't know, but we know, it makes us uneasy, okay? And that is a sentiment shared by Ms. Sweet. And one of my concerns in looking at the chart is that there's about 153 cases in the last 2 fiscal years that were referred criminally. Probably a lot of those are unlicensed cases over which HQE has very little jurisdiction unless there's an identified licensee. As you may know, we represent physician assistants and other allied healthcare agencies. But if on the unlicensed cases, we're less concerned. But where there is an identified medical board, physician or surgeon, I would be concerned about being shut out of any criminal case because these would be operated under the old handoff model, which is not ideal. These cases come to us and they have not been had involvement by our office, and we have to play catch up. And to play catch up in view of statute of limitations expiring is not ideal. So I will be working with Ms. Sweet, and we already had some discussions on this aspect. And at the same time, we can open discussions, if you wish, to see how the AGO, the Attorney General's office, can further serve your criminal prosecution needs. Our office already handles Medi-Cal fraud cases criminally, and 14 of our 53 HQE DAGs were all former prosecutors and city attorneys and AUSAs. Our interests remain the same as before, and we want to make sure that a proper determination is made such that we can work parallel civil administrative investigations and allow you to exert your authority over the criminal aspects of the Medical Practices Act. And of course, our main focus will always be timelines, quality, and public protection. And like I mentioned in my prior comment on agenda item number 22, the criminal cases pose a special challenge because even though we have those goals as the medical board, HQE and HQIU, DA's offices do not have that same pressure that we do under the Consumer Protection Enforcement Initiative, and they can take a long, long time. And so I share the commitment to make sure that we protect your interests and proceed where possible. And if we can carve out a disciplinary case and not get in the way of a criminal investigation, we will do so. That's all. Thank you.
Thank you, Ms. Castro. Are there any questions or comments from the board on Ms. Castro's report? Seeing none. Any comments from the phone?
No comments from the phone at this time.
All right.
And then just real quick, a staffing update. We just promoted former DAG and lead prosecutor Alexander Alvarez as our new supervising deputy attorney general out of San Diego. We promoted DAG for Matthew Davis to the lead prosecutor position in San Diego. And we have 2 new staff members. We have Mr. Gregory Chambers joining us in San Francisco and Rebecca Smith joining us in Los Angeles. And both are very talented private attorneys that gave up a significant amount of money to come and do your important work. And so we're very lucky to have them and everybody else on my staff, obviously. And then one final note is that the Solicitor General is requesting an extension on the filing of the Medical Board's Lewis brief. And so we will be in contact with Ms. Webb to let her know what date that is. Of course, you'll probably find out at the same time I do if they give us the extension. Thank you.
Thank you for that update, and congratulations on those promotions and larger team. We will now continue to agenda item 25, discussion and possible action on the adoption of a joint protocol with the Board of Pharmacy on naloxone hydrochloride. Ms. Kirkmeyer.
Under tab 25 on pages BRD 25-1 to 25-7, you will find the amended protocol for naloxone hydrochloride. As the members may remember, at the January board meeting, the board reviewed and approved a protocol under which pharmacists may provide naloxone hydrochloride to patients or others who may need to reverse or an opioid overdose. The Board of Pharmacy's emergency regulations regarding this protocol went into effect on April 10th. The Board of Pharmacy is now promulgating this protocol. Since the last meeting, the Board of Pharmacy has made a few changes to the protocol that the board had already approved. Therefore, the Medical Board must approve these additional changes so the Board of Pharmacy can continue the regulatory process. These changes were recently approved by the Board of Pharmacy on April 22nd, and the specific changes are found on pages 25-3 to 25-5. We do have Ms. Harold, Ms. Weiser, and Ms. McCammon here to answer any questions that the board may have regarding the recent changes to the protocol. If there aren't any questions, then I will need to have a motion to approve the changes as found on these pages.
Are there any questions or comments from the board? I don't see any. Thank you for being here.
I'll make a motion to approve the changes.
Second.
Second. Are any comments on the motion? Seeing none. Any public comment? Any comment from the phone on item 25?
No comments over the phone at this time.
Ms. Toof, please call the roll.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Abstain, and I'd like it noted for the record that I have a personal investment that creates a conflict of interest in this matter.
Okay. Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Mr. Serrano Sewell?
Aye, the motion carries. Thank you, President Weissner, for being here. Would you care to comment?
And thank you.
Thank you
It
for
would be
coming.
so easy.
Please send our best to your colleagues.
Okay,
Can I, David? Can I
Yes,
ask a
Ms.
question?
Absolutely.
Before you leave, there have been ongoing concerns about the price of naloxone, the availability of the intranasal form, and can you just give us an update about where things stand?
Well, a little.
Huh?
The auto injector, which is a wonderful device, comes in a package of 2, and it's currently available in pharmacies for around $600. So unless you're certain you're going to use it, it's a wonderful device. It's got a wonderful, no matter how panicked you are, you can literally use this. We think that many patients won't be able to afford that. We expect a lot of nasal to be used and some injection, but mostly the nasal because of the price. Under California law, you can have compounding done if there's a shortage, so pharmacies could arguably compound, but they have to show there's a shortage. There's not so much a shortage as there is an escalating price. And we're seeing this also in all areas of drug pricing. This includes generic drugs that are just literally skyrocketed lately. Those of you that buy drugs certainly are aware of that. So this is an issue bigger than the Board of Pharmacy, and I'm not sure where that's going to go. But because of the price, it will in fact probably affect who can purchase this.
There's also a problem possibly with insurance where if a representative of the patient comes in and to purchase it to have for availability, the possibility of insurance covering it without the true patient's insurance carrier would be problematic.
Well, and the reason I'm raising this is I think it's important for us to not overestimate the benefit of naloxone, which is a life-saving drug, based on what no one will be surprised to hear me say is an outrageous approach to pricing that is going to put this, is going to limit substantially its utility and availability.
I just wanted to speak briefly to the FDA approval of the intranasal product. I did a little bit of research before attending, and it is still in the approval process. The company that is sponsoring the research is actually still conducting another study that only began in December 2014, and so I imagine that the earliest date we're going to see FDA approval is the end of calendar year 2015.
And is there any likelihood that the pricing on that is going to be any better? It's going to be a sole source brand drug?
I unfortunately don't think that will improve it, at least for the first 3 years when there's exclusivity, possibly after.
I don't get to spend much time behind a prescription case anymore, but the price of drugs, generally speaking, everything, generics, every level, has really escalated incredibly and surprisingly.
Thank you for that additional information. We'll now move to, our pleasure. We will continue to agenda item 26, discussion and possible action on approval of Multi-Skilled Medical Certifications Institute, Inc. as a medical assistant certifying organization. Mr. Warden and Mrs. Webb will report. Thank you.
So please turn to your packet on page 26, 1 through 4. Multi-Skilled Medical Certifications Institute, Inc. applied to the board to be approved as a medical assistant certifying agency. This is done through the authority for that's through California Code of Regulations, section 1366.31, which is on page 26-4. The application has been reviewed by staff and then also reviewed by Ms. Webb and myself. This medical institute, Multi-Skilled Medical Certification Institute, meets the requirements for to be approved by the board, and I'd like to request a motion.
It's been moved by Dr. Lewis and seconded by Dr. Bishop. Members, are there any questions or comments? Yes.
Mr. Warden, is this a not-for-profit entity? Or?
Yes.
Are there additional questions or comments? Seeing none, are there any, I don't have a public comment card. Are there any comments from the phone on this agenda item 26?
Michael? No comments from the phone.
All right, thank you. Ms. Toof, please call the roll.
Dr. Bolat? Aye. Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins?
Aye.
Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Dr. Yip?
Aye.
Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Mr. Serrano Sewell?
Yes. One moment, please.
September 2014.
So we need the motion to be retroactive from September to 2014. That is the understanding in the motion, without any objection from the colleagues. All right. Thank you. That's incorporated in the motion. Thank you, Kirk. Item 27, discussion and possible action on proposed regulations to add the requirement for examination scores.
Okay. So please turn to your pages on Board Packet 27, 1 through 3. Business Profession Code Section 2177A, which is on page 3, states the board will specify the passing score for each step of the required physician and surgeon licensing exam as established by resolution of the board. The board has enacted a resolution on this issue on a yearly basis. The proposed regulation, if approved, would eliminate the need for a new resolution every year and provide the applicants clarification regarding minimum passing scores for each step of the approved process. I would like to have a motion to authorize staff with proceeding with the new regulation as proposed, and that's on page BRD 27-3, which would basically specify the passing exam would be set by the individuals who create the exams.
So moved.
There's been a motion. That's right. Ms. Yaroslavsky, second. Thank you. Any public comment? Seeing no public comment, any comment on the phone on agenda item 27?
Michael? No comment over the phone.
All right, thank you. Ms. Tuve, please call the roll.
Aye. Dr. Bishop?
Aye.
Aye.
Dr. Hawkins?
Aye.
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 Aye. Aye.
Aye.
Aye.
Aye, the motion carries. Thank you. We'll now move to agenda item 28, discussion and possible action on proposed regulations to update the outpatient surgery setting standards. Mr. Warden?
This proposed regulation is to make the corrections that we need, amendments to sections of the California Code of Regulations to match the new changes that are amended to the statutes, which are included in this. So the amendments to Health and Safety Code Section 1248.15A7 states that a outpatient setting regulated by this chapter with multiple locations shall have all sites inspected. Previously, the current regulation for this is Section 1314.1 currently says the actual sample size shall be determined by the accreditation agency. This is in conflict with Health and Safety Code 1248.15A7 and needs to be deleted. Health and Safety Code Section 1248.35 of the accreditation agency states the accreditation agency shall within 24 hours report to the board when it has issued a reprimand, suspended, or placed on probation or revoked any outpatient setting. Currently, California Code of Regulations 1314.4 only specifies denials and revocations must be reported to the board. Therefore, this needs to be amended to include those in the 24-hour section. I would like to have a motion to authorize staff to proceed with preparing the necessary regulatory amendments to amend Section 1314.4 and hold a regulatory hearing.
So moved.
Moved by Mrs. Wright, seconded by Ms. Yaroslavsky. Members, any questions or comments? Seeing none. Oh, absolutely.
At any time, has there been thought as to posting of who is accrediting the specific surgery center for the public to be aware of?
The actual on our website, the accreditation agency that accredits the specific center is listed, but once again, our website doesn't include every outpatient setting out there because of the different methods of being licensed or accredited.
So the only way a consumer would know is if they knew to go to the website to look, but there's nothing in
No,
the-
there's already a law in 1248.15. There's a section that requires the outpatient surgery setting to post a notice as to who their accreditation
Okay, thank you. That's what I
agency is.
was wondering.
It's already there.
Thank you.
I forgot about that.
It's all right. Thank you. Thank you, Mr. Warden. Are there additional questions or comments? Seeing none, are there any comments from members of the public? Any comments from the phone on item 28?
No comments from the phone.
Thank you. Ms. Toof, please call the roll.
Dr. Bolat?
Aye.
Dr. Bishop?
Aye.
Dr. Gonadev?
Aye.
Dr. Hawkins? Dr. Kraus?
Aye.
Dr. Levine?
Aye.
Dr. Lewis?
Aye.
Dr. Yip? Ms. Pines?
Aye.
Ms. Shipsky?
Aye.
Ms. Wright?
Aye.
Ms. Yaroslavsky?
Aye.
Mr. Serrano Sewell?
Aye. Motion carries. We'll now move to agenda item 4. Agenda item 4, board member communications with interested parties. I'll start it off and report on behalf of two people here. Yesterday, I had a non-hosted breakfast with representatives from CMA to discuss, along with my colleague Dev and Kimberly, to discuss the board's strategic agenda, including a host of issues, including a physician wellness program. I also had meetings in early part of this year with the Consumer Watchdog Group to discuss the board's consumer protection efforts, including changes to the Cures program. That was with Carmen, Jamie, and Mr. Bob Pack. Any other? Mr. Bishop, Dr. Bishop?
Whatever. I've had a meeting with representatives from the CMA with respect to from the CSA with respect to Bill 890, and representatives from CAPA, the PA organization for Bill 337, and also had the great honor of speaking with Speaker Atkins last week just to kind of get a general sense of our relationship.
Oh, thank you for meeting with the Speaker's office. To my left? To my right? Dr. Levine?
As previously reported, I've been appointed to the board of IMQ and attended the first board meeting at which the CME, the proposed regulations on adjustments, amendment of the CME requirements for licensure was discussed. And I recused myself from that discussion also.
Thank you, Dr. Levine. And no, yes?
Just to repeat, as I am on the AMPAC board and am past president of CMA, I do meet with CMA, AMA, AMPAC, all kind of agencies, but we will not discuss medical board issues.
All right, thank you.
Mr. Chair?
Yes, Ms. Shipke.
Just kind of a point of order. When I proposed this item that we would have that similar to the Coastal Commission, it really doesn't serve us well if it's at the end of the agenda. It's supposed to be taken at the beginning of the meeting so that the public is aware as we start discussing any of these issues, if any of us have had discussions with, we've had ex parte discussions, and that's the intent at the Coastal Commission. That was the intent when the board adopted that item.
I'll be more mindful in the future. Dr. Hawkins?
As a new member, is there a requirement, and what is the nature of reporting this?
I'm going to ask, that's a very good question. And I'm going to ask Ms. Kirkmeyer if that's okay to opine on it. To comment briefly?
Yeah, unfortunately, my board member administrative procedure manual's in the back, but it basically was originated by Steve Alexander, who started it with, I think that was when Ms. Shipsky was also on the board, and it was a discussion amongst the board. And it really was actually what Ms. Shipsky has stated, that individuals, if there was discussions with outside interested parties, that it would be made known to the other board members that you had been talking to these individuals on items that were particular to the agenda or the board's function. It was just a public communication, making it known amongst your members and the public.
And I've interpreted it as a nexus between, as Kimberly has said, your duties as a board member and an agenda item, so the public knows, disclosure, that that dialogue has happened. This is my personal view now, which I would also like to share. There's nothing wrong with having those meetings. And in fact, when I was appointed, the governor didn't object, or his staff, to having such meetings, and I view it as something I need to do as a public official. Disclosure is important. So long as people know, it's fine. So that's why this agenda's item is on.
And it's not about relationships, it's about discussions that relate to business that's before the board.
That's very important. Thank you. Okay. Is there any public comment on this? Any public comment from those in the audience on agenda item 4? Are there any comments from those on the telephone?
No comments from the phone.
All right. The next agenda item is 29, agenda items for the July 2015 meeting in the Bay Area. Items for the next agenda could include, are suggested, regulatory hearings for disciplinary guidelines, regulatory hearings on the board's disclaimers on explanatory information. Oh, we did the website. We may have to take action on that from Ms. Romero's report. Regulatory hearing on outpatient surgery setting standards, a presentation by Jeanette Kaufman from the University of California, San Francisco, on their study with the board on physician participation and Medi-Cal, and a presentation by FSMB, who will be visiting us during the July meeting, and Physician Health. Thank you. Do members have any additional suggested agenda items for the July board meeting? Yes, I'll look to my left. Ms. Wright?
2, please. The licensing committee hasn't met in a while, so can we get some kind of update? That would be great.
Okay.
And secondarily, the demographic study that's going to happen as to discipline to doctors based on race and ethnicity. It would be great to get an update on the status of that, where it's going, and any interested parties that have had feedback.
Okay.
Thank you.
I'll look to my right. Ms. Shipsky?
It would be helpful, I think, if we could get an update on the impact of the Affordable Care Act on physicians, particularly on the mandate for compliance and ethics programs within practices, as well as the accountable care organizations, because that's significantly impacting physicians. And I don't know if the board is going to have to make any adjustments down the line because of that. And then the other issue would be if we could have some kind of discussion as to how we can more publicly notice when a physician's been put on probation. Should there be some kind of mandatory requirement the physician informs his or her patients that they're on probation? Because we're assuming the general public can get online. But if we could just start that discussion as to whether or not that would be possible.
Dr. Levine, did you have your hand up? Okay, I'm sorry. Dr. Krause?
I'd like to have an agenda item regarding achieving and maintaining uniform standards of care. And I'd like to invite the FSMB visitor to discuss that as well. And more specifically, it's really an issue for the Department of Consumer Affairs in terms of how we best provide oversight of licentiates in all boards with newly legislated privileges to practice medicine and surgery.
Ms. Yaroslawski, did you have your hand up? Anyone else? Okay. Do any members have, is there public comment from those in the audience on future agenda items? Ms. Film.
Good afternoon, Julie D'Angelo, Falmouth from the Center for Public Interest Law. I strongly suggest that you seek from your attorneys an explanation of the U.S. Supreme Court's holding in the North Carolina Dental Board case and its impact on this board.
Thank you. Are there any additional public comments? Are there any comments from those on the phone on agenda item 29?
We do have a comment from Genevieve Clabriol.
Genevieve, if you're on the line, can you please make your comments on agenda item 29? All right. Before we move to agenda item 30, adjournment, I would like to thank the members for another great meeting and thank our staff for doing such a phenomenal job. And that is Lisa, Dino, Regina, Les, Armando, Jennifer, Kurt, Paulette, Carrie, Diane, Liz, Lou. Thank you so much. Our Executive Director, Kimberly. I will now entertain a motion to adjourn. Without objection, we stand in adjournment.